Good morning, and welcome to the District of Columbia Court of Appeals. We're sitting en banc today in the matter of DW versus United States. We're joined on the panel today to my far right by Senior Judge Stephen Glickman, who participated in the panel decision in the DW case, by Associate Judge J.P. Howard, Associate Judge Roy McLeese, Associate Judge Corrine Beckwith, and to my left, Associate Judge Catherine Easterly, Associate Judge Joshua Deal, and Associate Judge BJ Schenker. And I am Chief Judge Anna Blackburn Rigsby, and pleased to welcome you here this morning. The court is sitting en banc in this case, and the central issue of the case is whether police officers had a reasonable articulable suspicion pursuant to the U.S. Supreme Court case of Terry versus Ohio to conduct an investigatory stop of appellant, otherwise known as a Terry stop. As relevant here is Illinois v. Wardlow, another key Supreme Court precedent, where the court explained that flight and characteristics of location may be among the relevant contextual considerations in a Terry analysis. In 2023, this court decided Mayo versus United States en banc, in which we held that in assessing reasonable articulable suspicion, flight must be examined in the context of the totality of the circumstances, and that general locational evidence may provide context for police observations of ambiguous conduct, but its appropriate weight will turn on its quality and specificity. Prior to the issuance of the en banc opinion here, a three-judge division of this court heard this case, DW versus United States, and this case was then held in abeyance pending the court's en banc decision in Mayo. After supplemental briefing and a special sitting in DW versus United States, the majority concluded that police officers lacked reasonable articulable suspicion to stop appellant in that case. The division felt that it was bound by the Mayo en banc precedent of this court and by the Posey versus United States case in this court, among others. The division vacated and remanded the trial court denial of appellant's pretrial suppression motion. And shortly after the opinion was issued, this court voted sua sponte to rehear the case en banc and vacated the division's opinion. The en banc court limited its consideration today to one question: whether the police acted lawfully when they initially seized DW, whether that investigative stop was supported by reasonable articulable suspicion. So with that, pleased to welcome you all. Each side has been given 45 minutes per side, and you can reserve some of that time for rebuttal. Are we ready to proceed?
Good morning, and may it please the court, Jacqueline Frankfurt on behalf of DW.
Ms. Frankfurt, could I ask you to make sure the microphone is adjusted there?
Yes, is that better?
Yes.
Good. I would like to reserve 5 minutes for rebuttal.
Thank you.
I plan to focus my argument today on why reversal is required under the principles this court articulated in Mayo, and why that result is consistent with the Supreme Court's decision in Wardlow. And that argument will rest on two basic points. First, that the locational evidence presented at this pre-Mayo hearing, like the evidence in Mayo, lacked the relevant non-conclusory details, the quality and specificity that would allow such evidence to give context to the necessarily ambiguous conduct of DW's flight. And second, that as to that flight, the context evidence in this record, both the actions of the police and the reactions of the people they encountered, demonstrated that individuals in this area had reasons to avoid engaging with the police and therefore may take flight for those reasons, even if they had engaged in no wrongdoing, which would necessarily reduce, in the words of Mayo, the value in the reasonable articulable suspicion analysis.
Could I jump in and just ask here to make sure I'm clear on the record? My understanding is that DW took flight and maybe did not witness some of the actions that you reference by the police here. The officers were 50 feet away or more, approaching the buildings in the Geraldine complex when DW immediately took flight there. He didn't stick around to see what, if anything, they did to any of the residents there on that date and time. How then should we weigh some of the other evidence that later comes in and gives us perhaps more details about what happened after he took off running?
Yes, I think, Your Honor, that you're correct, that he did not witness those actions. But reading the transcript, the defense lawyer was extremely clear, and the trial judge was extremely clear in allowing the cross-examinations as to why she was eliciting the information about how the other people reacted. The Miles decision had already come down. She said how the community reacts gives you insight, gives context and insight into the aggressive policing that has happened in this area. And every time she elicited information about how, for instance, one person put their hands up in a T when she cross-examined Officer Bewley, she said, and that is a typical reaction. You've seen that many times at the Geraldine. And he said, yes. And when one person lifted their shirt, exposing their entire torso,
Right.
She again elicited that. So that information was not elicited to show that DW had in some respect seen it. And the same with the incredibly invasive search of the man in the blue shirt. She elicited that as typical.
Well, but if we're looking at the nature of DW's flight, and in many instances, when we talk about flight in a criminal context, we're talking about consciousness of guilt, perhaps. And so I guess my question goes to why we should view his flight here differently. Maybe if he had fled after seeing people hold their hands up in a T or see them chase the other gentleman in the blue jacket, that the inference that I hear you drawing about his personal safety or fear could be given greater weight. I'm trying to just pin down why under these particular circumstances here, where he runs first before witnessing any of this, we should give that inference.
Because, Your Honor, the context in which he ran includes what has happened before. So, for instance, a year ago, perhaps, if a police officer or a border patrol or an ICE officer came into Mount Pleasant and someone ran, certain inferences related to consciousness of guilt could be drawn. But fast forward a year, and if a lawyer introduced into evidence all the evidence about people being stopped when they were citizens and when they had their citizenship papers but were nonetheless held for 4 hours, all that becomes context when you look at the fact that when Border Patrol or ICE comes into a neighborhood, people scatter. Now we have a different context for that flight. And it's not a question of whether they saw every piece of it, but whether it is reasonable to believe this community knows what those officers are going to do, because the minute they step out of the rolling cars with the doors open in the flashbang area, a number of people react that way.
But Ms.
That's not
Frankfurt,
normal.
you referred to everybody scattering, and the truth is, in this case, not everybody ran. And I think you chose the word scatter for a reason, because that sounds different. How much does it matter that a lot of people didn't run, and would it be different if he was the only one who ran?
I think what matters here is that in the relatively small universe of people who were on the sidewalks or in the area when the police came out, at least 4 took actions to avoid police engagement. And I think that we can't look at it as if it's normal for people to raise their shirts or to raise their arms in response to the police arrival. That
But why,
doesn't-
why not? I mean, we've said, and the Supreme Court has said, that people have a right to refuse to cooperate. We've also said, and the Supreme Court has said, that law enforcement has a right to engage in consensual encounters and ask questions. And so if folks there say, I don't want to engage in that consensual encounter, so I'm going to head it off and preempt it by lifting up my shirt or putting my arm out in a T, then that's consistent with both of those propositions and is distinguishable from someone who doesn't do that, but instead takes off in what has been termed headlong flight. And just to, sorry, ask a compound question, but you mentioned it shows what we know the police officers are going to do. I think you said something like that. And what is that other than perhaps, I mean, we don't know that they're going to tackle people, put their heads into the ground. We know at most at this point that they're going to perhaps ask questions, right?
I actually think that we know from the Supreme Court that people have a right not to engage. But I think that if the individuals on the street thought that saying, I'd rather not talk right now would be enough to avoid police engagement, then they would use that tool. It's a very simple one. You don't have to expose your body. You don't have to lift your arms. And the fact that these individuals are doing something different than that, I think the inference to be drawn is that that's not sufficient. And with, our case law, our case law bears that out in that we have so many cases where a shirt is lifted and that's not enough. The other side of the shirt has to be lifted. A question is asked, an answer is given, and that's not enough. Another answer has to be given. A shirt is lifted, and then a request to hike the pants. I mean, I could cite all those cases, but I also think it's a natural inference from the fact that I don't lift my arms when police officers walk by me.
Can I just ask?
I don't lift my shirt. And I don't know if you do, but there's something that is causing these men to do those things. And I think that it's the obligation of the court to consider that context, because if that's normal, then it would be happening, then the women would be doing it, and it would be happening in all parts of the city. And I don't think it is. And I don't think the government would say that it is.
Can I just get a sense of how you're counting the numbers when you say at least 4 people? I take it you are counting DW as one runner, the man in the blue shirt as number 2.
Yes.
The man who remains in that pathway that the officers are coming down, who lifts up his shirt as the only one of the 5 people who remain who acts in that way. Is that right?
Yes.
And then the individual who does the T shape in response to Officer Ewing, while 3 people seem to be nearby and don't have any reaction to him. Is that right?
Yes.
I mean, it sounds like if you take flight out of it, you're talking about, 2 out of, I think, 10. I'm not sure if I have that number quite right. 2 out of 9. It's not nothing. I agree that it's certainly some indication that people in this community do not feel free to go about their business when officers come by. I'm not sure what to do with that information. I mean, you guys could have put on evidence that, you could have called witnesses to say, this is the way, this is the telltale jump out sign that lets us know they're going to search us whether we like it or not. And everybody knows that in this neighborhood. But asking you to infer it from the way 2 out of 9 people react when 7 other people don't seems like a lot.
I don't think it's a lot because of the uncontested testimony of Officer Ewing. Because one person lifted his arms in a T, but then on cross-examination, the defense lawyer elicited that was a typical reaction. He saw it all the time. One person lifted his shirt, and then Ewing indicated that was a typical reaction. At the Geraldine, one person was groped when they were searched in their genitalia. They were handcuffed despite the fact that nothing was found. They were put up against a fence for 30 minutes. And Officer Bewley testified that was typical way to conduct a search at the Geraldine. I mean, Terry talked about the no petty indignity of someone having to raise their arms and be up against a wall. And the indignity here is handcuffed on the ground on the
So
concrete.
I'm glad you talked about one of the cases here at issue, which is Terry, and the ability of police officers to do a Terry stop. Can you talk about sort of Wardlow and I guess those two cases for starters, and what was problematic here? Because that prevented the officers from being able to do investigative stops that they would normally do under Terry. Is that what you're saying, that they did not have the reasonable articulable suspicion here to do any type of investigatory stops? I'm trying to fit in the factual scenario of the prior evidence of police activity in this area and how residents reacted to the legal framework under Wardlow and Terry.
So it's interesting that in the oral argument in Wardlow, when the Solicitor General was arguing and they were pressing him to recognize that it was best contemplated as totality of the circumstances test. And he was talking about provocation versus no provocation. Justice Scalia said, well, you know, he wasn't thrilled with the word provocation. And he said, there could be a lot of else's, though, besides mere provocation, couldn't there? I mean, there were instances a few years ago in the Washington area in which some man was posing as a policeman in a police car and put up a red light on top of the car and stopped women and robbed and raped them. Now, what if something like that had been going on and a woman is driving in a car and a real policeman, et cetera? In Justice Scalia's view, that was context. That was something that happened in the past that would be context for why a woman might flee a police officer. It changes the analysis of the flight because it might be something other than consciousness of guilt. And the Solicitor General responded, I think certainly if the individual could establish that within a particular community, it had become the norm for someone to flee from the sight of a police officer for whatever reason, or if that had become typical behavior within the community. And then he goes on to say that under the totality of the circumstances test, I think the individual always will have the opportunity to show that other contextual factors made it unreasonable for the police officer to infer guilt from the fact of flight.
Counsel, so I guess where I get tripped up a little bit here is where's the evidence that DW is part of this community? I mean, obviously he's there. But I don't know that we know that he lives nearby, that he's ever been there before, that he's really part of this community. So just assuming that there is strong evidence about the community reaction to the CST policing at the Geraldine, don't we need that connector for DW? And if we do, what do we have here?
I think what we have is a mode of approach by the police officers that this court has determined sort of the flashbang method of approach, where the police officers come to a rolling stop, cars open before the doors are open, and multiple police officers approach. And then which this court has said is designed to result in temporary paralysis or flight. And then some people don't move, and some people do, including DW and the man in the blue shirt, one of which has a gun on him, one of which doesn't, and then the two individuals who raise their arms or lift their shirt. And I think that with the testimony of Officer Bewley, that both that the reactions are typical and that the conduct in the aggressive search of the man in the blue shirt is typical. I think that gives context without, I mean, all we know is that he's there, right? And as are many other people. If there had been no history, I think the arm in the T and the shirt lifted up wouldn't make any sense. Like, why would those things happen if there had been no history?
But you seem to be saying that the fact that there are innocent reasons that people might engage in certain conduct essentially zeroes out that factor in the totality analysis. And I don't think we've ever said that. I think we've said the opposite. And I think the Supreme Court has said the opposite. I mean, there are a lot of innocent reasons people might start throwing things out of their pockets, but that doesn't mean that that's not a factor in the reasonable suspicion analysis.
I don't think it zeroes it out. I think that this court has said both that in evaluating the totality of the circumstances, it's improper to reject a factor solely because it's susceptible to an innocent explanation. And it has also said that if the observed behavior is capable of too many innocent explanations, then the logical gap between the behavior and the suspicion signals the intrusion was unreasonable. So we're talking about a scale. And so we're talking about when the Solicitor General's office filed a brief in Wardlow, they used the word aberrational to describe flight, like over and over and over again. And so now we're talking about, is this a record on which the innocent explanations, given the context, given the way people are reacting, and like I haven't gone to sort of the case law about aggressive police conduct, how it affects communities, how it affects the Black and brown men in communities. But just on the record here, if the innocent explanations sort of, as this court said in Golden, if the potential innocent explanations increase, then the logical gap for reasonable articulable. So I'm not asking anyone to zero anything out because I don't think that's what the totality of the circumstances test requires. But I am saying that Wardlow requires and Terry requires a view of everything that's happening in context. And that in Wardlow, when officers drive by and someone catches an eye and flees, that's a different context than when the flashbang proactive policing occurs and the context and the reactions that happens there. I think that the court would be blinding itself if it equated those two things.
Can you tie those in, the facts that you're describing, the testimony about the police tactics or the flight here, into the rubric of our case law? The division felt it was bound by Mayo and by a prior case, Posey, and therefore had to find that there was no reasonable articulable suspicion here. We're sitting en banc now. Should the division or should the en banc court look at our prior precedent in Mayo and Posey differently? Should we revise it so that there would have been greater latitude here for the division to find reasonable articulable suspicion under the circumstances of the facts here? Are you suggesting that they correctly found under these facts that there was no reasonable articulable suspicion?
I believe that the division correctly found that there was no reasonable articulable suspicion on these facts. I think that flows from Mayo, and I think that flows both from the analysis that's required as to locational crime evidence, which here I think was extraordinarily weak and not sufficient quality and specificity under the test that this court set forth in Mayo, and therefore couldn't add context to the flight to make it more incriminatory. And I think as to the flight, when the Mayo court said that,
Can I ask you,
yes,
wasn't the context, the locational context, and that since DW was argued initially before Mayo, it was referred to as a high crime area, the Geraldine apartment complex. Isn't that more detailed than the locational information we had in Mayo, where Mayo was talking about an entire neighborhood, broad-ranging neighborhood, the Kenilworth neighborhood in the city? Here in DW, the testimony and evidence referred to a more discrete, narrower community, one housing project. Doesn't that give us a little more of a narrow context? Perhaps, as I look at it, maybe not as narrow as what we had in Wardlow, where there was talk about an open-air drug market that drew the police to that area. It is seemingly more narrow and focused than the information we had in Mayo.
It was more focused in one respect, which is the geography. But when the officers, so each of the officers testified it was a high crime area. Officer Bewley said a pretty high crime area. And then when the lawyers drilled down, both the prosecutor and the defense lawyer, it became clear that there was no specifics. It was very weak on time window. Officer Bewley said it was a pretty high crime area. And the prosecutor said, did you personally have experiences responding to police reports? He said, yes, I have. What kinds? Homicides, assault with dangerous weapons, guns, knives, general crimes, no time specificity. And then she focuses on recovering guns, and he says, I don't know exactly how many I recovered. And when she asks how many crimes would make an area high crime to you, the officer responds, I would say in the same building, same complex, I would say anything over 5 or 10 in a certain amount of time. He did not say in a year, as was written in the panel opinion.
But he's asked at page 100 of that testimony within a year.
I'm sorry, what did you say?
It's clarified at page 100 of the transcript. They say, what about between August 25th, 2016 and August 25th, 2017? It's a 1-year time frame, and he says he sticks by 5 to 10 violent crimes. I don't mean to derail you, but
I thought that was a question about a different set of facts, but it may be. And
I will say it is not so closely tailored to this complex, but it is an officer who says, I would consider an area, it's an officer who says, Geraldine Complex is a high crime area. What do you consider to be a high crime area? He says 5 to 10 violent crimes within a year. And that's pretty clear from the testimony. So I don't mean to derail you.
Which I still think is not really more than the weak tea in Mayo, and is not differentiated as to crimes. When he's asked about gun recovery, he says he doesn't know. Officer Ewing keeps saying numerous firearms, narcotics, multiple stabbings, shootings, but when the prosecutor asks, over the course of your career, which is 4 years long, how many firearm-related arrests have you made? His answer is more than 5, I think. I don't know the exact number. So if more than 5 in 4 years is his view of numerous, that testimony also is what I think the court characterized as weak tea. And he says, when asked to characterize what high crime is, he says, I just don't know. His answer in every other respect is I just don't know.
Yeah,
Please.
sorry. I wanted to get back to sort of the chief's line of questioning of, whether the panel opinion correctly followed Mayo, or, whether some adjustment needed to be made. And I wanted to talk about the flight analysis, because the panel opinion in the flight analysis seems to rely simply on Posey instead of doing a totality of the circumstances analysis. And so, I mean, is it your position that that's correct?
I would, that's why I appreciate it, because I don't think I got there when I responded to the chief. I would say that I think reversal is required, but I think it's required by Mayo. I think it's fine. I think Posey was correctly decided, but I think Mayo gives more of guidance of how to analyze flight in this case. I think that the panel opinion gave a sense that Posey was a categorical ruling, and I don't think Posey was a categorical ruling. It explicitly issued box checking, and it recognized.
The panel points to a particular quote in
Yes.
Posey that says, a nondescript individual distinguishing himself from an equally nondescript crowd by running away from officers unprovoked does not, without more, provide a reasonable basis for suspecting that that individual being involved in criminal activity and subjecting him or her to an intrusive stop and police search.
That is-
And
Yes,
so the panel interpreted that as categorically, you can't just have flight. Do you agree that that was a correct interpretation, or is there a different
I
reading?
think the sentence before that is, under the totality of these circumstances, the officers approached the group and acted on a hunch short of individualized and particularized suspicion, a knowledge needed to stop Mr. Posey on suspicion of robbery. I think that the Posey case was a case where the police got a description of a person who had been involved in an armed robbery. And the entire focus of the opinion was whether there was reasonable articulable suspicion to believe that Mr. Posey was the person who had done the armed robbery. And indeed, they not only stopped, but they frisked Mr. Posey. So there would have been no grounds for that frisk if he was not linked to that robbery. And the entire focus of the opinion, which explicitly says they have to do a totality of the circumstances analysis, which considers all the facts.
I don't, you're throwing me with the phrase entire focus. I mean, the quoted passage, I think, makes clear that it was not the entire focus, that the court was taking among the totality of the circumstances, both the information about the tip, but also the flight, and was assessing how they added together. So I'm not quite sure what you mean by entire focus.
I think they certainly were assessing the flight and whether it gave the police reasonable articulable suspicion to believe that Mr. Posey was the armed robber, nor did Officer Casco indicate that the manner of Mr. Posey's flight was in itself suggestive of armed robbery. I think it's correct that unadorned flight with no context to make it more incriminating. I think pretty much every circuit has said that Wardlow is a floor and that flight alone is not reasonable articulable suspicion to believe someone has committed a crime. I don't see that Posey, I don't see that. I mean, this court could take that from Posey, but I actually think Posey was doing a more contextual analysis of what impact flight has on the suspicion that Mr. Posey was the armed robber.
Can I ask you about, you said that you think that that kind of Wardlow itself, without a need for reliance on Posey, dictates a conclusion of reversal here, and that the analysis of flight in Wardlow supports that assertion. I hope I'm not putting words incorrectly in your mouth, but that's what I took you to say. And
Mayo or Wardlow?
I'm sorry, Mayo, excuse me. Yes, that Mayo, yeah. And I guess that what I am curious about that line of thinking is that in Mayo, the circumstances of flight were significantly different in ways that the court in Mayo emphasized, because there, whatever you think of the somewhat ambiguous term provocation, the court put a fair bit of weight in assessing the significance to be given to flight in Mayo, to the circumstances that preceded it, not just general information, some of which, general information about law enforcement in the area and things like that, but also day of case-specific interactions between the police officers and Mr. Mayo before Mr. Mayo fled. And so the circumstances of the flight in Mayo thus seem quite a bit different in ways that the court in Mayo emphasized from the circumstances of flight here.
I think it is true that Mayo focused on targeting as one of the factors, and that we don't have targeting here. When I say that I think that the case is governed by the principles in Mayo, I think that, the facts are different, but the principles are the same. If you take from the reactions of the people on the street, the notion that the police approach communicated that they were going to engage with these people, that the reason that they were responding that way was to avoid engagement with the police. And so when Mayo said the GRU officers should have known that individuals such as Mr. Mayo and his companions would fear their approach and might take flight even if they had engaged in no wrongdoing, I think the same could be said here. And when Mayo said, when the aggressive nature of a police presence in a community makes flight simply to avoid police interactions a plausible response, such flight cannot automatically be understood as a manifestation of consciousness of guilt, and its value in the reasonable articulable suspicion analysis is significantly reduced. I think the same can be said here. So it's not that the facts are identical. The facts are rarely identical. There wasn't the flashbang departure in Mayo. They started in their cars, they talked out the window. It wasn't until they converged on Mr. Mayo that he took flight. But here the approach was different and the reactions were different. But I think the same principles say that there are reasons other than consciousness of guilt that in those two individuals could have fled, and that has to
Could you
decrease.
clarify something for me? When you say there were plausible reasons other than consciousness of guilt, I'm wondering where that DW might have fled. I'm wondering where that gets you. Under reasonable articulable suspicion analysis, there certainly can be plausible reasons for the headlong flight consistent with innocence, but it's enough if there is a plausible reason that suggests that there is wrongdoing to justify reasonable articulable suspicion. So where does it get you to say that there are plausible reasons that that DW might have fled, even if he were innocent?
It's you know, as this court's case law makes clear, it's all a question of degree. And so when in May, for instance, when we're talking about stuffing motions or things of the sort, if something becomes consistent with too many innocent explanations, then its weight in the reasonable articulable suspicion analysis is decreased. The
That's just-
plausible
I get
reasons
thrown by the
language
too-
comes
the-
from
the- by
Mayo.
the too many explanations. It seems like there's one innocent explanation. It depends how, I guess, how you're counting them. And it's less how many options there are on the list and what the probabilities are about the other innocent explanation. I mean, one way of counting is that the idea here would be either the defendant is fleeing because the defendant is guilty of an offense, or the defendant is fleeing because the defendant fears reasonably, maybe, or unreasonably, or who knows, but fears unwarranted police interaction. Indignity of it, the risk of being injured or shot, the risk of false arrest, all those. I mean, it's not that the number of innocent explanations is greater here or smaller here than in Mayo or in Posey or any of them. It seems like it's just depending on the circumstances, the probabilities that one of them is the cause as opposed to the other are being altered. Do you see it that way or a different way? And if so, could you shed a little light on it?
I think I see it that way. I think that when you look at the record in Wardlow, it's context-free, right? Police officers are driving by, someone catches the eye and flees. And so then the court has to assess likelihood of innocent explanation, likelihood of alternative explanation, and the such. When you look at this record and this context, and you see what happens to the man in the blue shirt, is there an incentive to avoid that? I think the court has to factor that in. And you see the reactions of the individuals who are doing things, I think, to demonstrate that they believe that saying, "No, thank you, officer," may not end the interaction. I mean, the whole operating principle on Wardlow is that people are free to decline. So flight is extraordinary because, you know, people can simply go on their way.
So, counsel,
And I
let
don't
me
think
ask
this
you,
record leads to that conclusion.
you focused almost completely on everything leading up to what his understanding could have been at the moment that he decided to take off. In your view, and you didn't go much beyond that in the supplemental briefing either, in your view, how much can we consider things after he took off, the particular desperation of his flight or any other characteristic beyond that point?
I think the court can consider it in the totality of the circumstances analysis, I just don't think that that once we acknowledge this person is trying to evade police interaction, once he's running and he's running hard, as more and more, I think, starts with 2, becomes at least 4 police officers are chasing him and converging on him. I think the fact that he continues to run hard, goes over to fences that the police officers also go over. I mean, they're going up chain link fences. I just don't think it adds very much. I do think character of flight can be part of the analysis. I just think the character of the flight here doesn't add that much once we're already accepting that he is running to avoid the police interaction. He might have even more reason to avoid the police interaction once that many officers are converging on
Do
him.
you see a distinction from Posey there for us then? In Posey, it seemed like was running potentially to try to get into a house or an apartment and go a very short distance. Here, you're talking about running, and if I were to describe it humorously, this almost turns into a side-scrolling video game where the cops and DW are kind of jumping over fences like Mario or something. Like there's a lot going on here, and it looks particularly intense.
I guess so, although the cops were making it over the fences too. And, this is a teenager running and going over fences. I don't know whether, Mr. Posey was trying to avoid interaction by going into a house. That's why I say it's part of the context. I just don't see that it really adds a tremendous amount. And the government hasn't cited a case where the sort of continue to flee is the tipping point on a totality.
Counsel, I'm a little
analysis.
confused about your ultimate position on one question, which is devoid of the context of the police history with this particular neighborhood or group of folks. It seemed like you suggested that under Wardlow, if all we know is that the police are approaching and someone takes off in headlong flight, that can be sufficient alone to support reasonable articulable suspicion. But I think you also said the opposite earlier.
No, I think the holding in Wardlow is when that, I think when I said that, I was talking just about the flight factor, but the Supreme Court in Wardlow made clear that it was only making that holding in the context of approaching an active narcotics trading open air drug market or whatever.
And so you think that then you think Posey did get it right and did say that flight alone can never be enough, right?
I think it is correct that flight alone can never be enough. I can provide the court in a 28K letter some 2018 case from a court in Illinois that has a footnote saying every single federal circuit to consider the issue has held that that Wardlow is the floor and that flight without additional context is not enough to constitute reasonable articulable suspicion. I think that's correct. I think if this court wants to take that from Posey, it's fine. I actually think that I don't think Posey was articulating a categorical rule. I think it was doing a totality of the circumstances analysis. And I think what it was really doing was saying that the flight didn't give the government reasonable articulable suspicion to believe Mr. Posey had committed the armed robbery. I don't think they really had reason to assess the question of flight for a Terry stop because there was a frisk. So they were always focused on this armed robbery. But I think it would be a correct holding that if you had a case.
Can I test that holding, Counselor? Let's say an officer is at a baseball game and he starts walking up the aisleway and somebody in the crowd in a seat sees the officer coming toward him, jumps up, runs down the opposite aisleway, jumps off the upper deck down to the lower deck, maybe let's call it a 25-foot drop. No reason to think that officer was coming to him. No reason to think that officer was focused in on him, very unlike Mayo. Willing to flee in a way that puts, his life in peril. you think that wouldn't be a reasonable articulable suspicion that that person is engaged in criminal wrongdoing? I mean, I guess I'm saying like the degree to which officers are focused in on the person seems to matter a lot. And the character of the flight seems to matter at least a little bit. And if you take those things to ridiculous degrees, I think the proposition that flight can never provide reasonable articulable suspicion is a tough one to defend. So I'm curious if you want to defend it.
I have no desire to defend it because I don't think it's present in this case. I will say that that case would be a first, probably. You know, Hodari D reserved that question of whether flight alone constitutes reasonable articulable suspicion. Justice Scalia thought it did, citing the Proverbs. But the Supreme Court didn't decide it in Wardlow. It's open from the Supreme Court. Minnesota court says, the United States Supreme Court has never decided whether evasion from the police standing alone can justify stopping a pedestrian. We observe in passing that all the federal circuits seem to accept Wardlow's implication that stopping a pedestrian requires more than evasive conduct by itself. I'm not saying that like the baseball game, the jumping, the falling, all that, maybe. It's just that there wouldn't be a whole lot of cases in the government's brief.
Sure. I guess let me just focus on one element of it. I mean, this is kind of what to me is a pretty big distinction between Mayo and this case. And I'm just curious how much you think it matters. So to me, a big part of this question, we sometimes refer to it as provocation. I kind of think of it of flight is far less incriminating if somebody has been given reason to think that they are not free to go about their business. In Mayo, that individual was definitely given strong reason to think he was not free to go about their business. Here, I'm less sure. Here we have a guy who's standing with 7 people, 2 officers still quite a distance away from them. I would put it at 75 to 100 feet with multiple. There's a door on the left, a door on the right, a door in front of them. I don't quite think of it as the flashbang that you keep describing, because they're not jumping on top of those people. It seems reasonable enough to me to think that DW could have walked away from that. And if I'm wrong, and that they chased then, well, then he might have cause to run. But there is what is the evidence that DW was given reason to think he was not going to be free to walk away from that interaction? And is it that one person showed his waistband and one person did a T, and that happens in that neighborhood? Is that the extent of it? Was anything particular to DW?
If it seems really casual to you, then I have a really long road to hoe. Because when I view that as sort of extraordinary. I view it as extraordinary that people in the community think they need to expose themselves or willfully subject themselves to searches in order to avoid police interaction.
What if the more natural instinct is that Black men aged 20 to 30, or 15 to 30 have that instinct? It's not about the Geraldine complex. It's not about police activity there. It is about, as Carter might put it, the interactions between Black men and police. And if that is sort of the baseline, then I don't know where that leaves us. I'm sure you think that tells us that Black men fleeing from police is not reasonable articulable suspicion. That seems very hard to square with Wardlow.
Well, I actually don't even know the rates.
I don't know why.
I think this court could write an opinion based on Carter. I don't think this court has to write an opinion based on Carter, but Carter has some extraordinary statistics within it, such as over 50% of Black adults, not just men, have feared for their life in interactions with law enforcement. So I think I think the court could but need not use that kind of information, but need not, because in this record, there is strong evidence of Black men doing things to really try to avoid police engagement. But I don't think this court can look at that in light of Carter and say, that's so ambiguous. I mean, it's really not ambiguous. I mean, against the backdrop of something like Carter, we know why they're exposing their bodies and we know why they're lifting their arms in the T. And Officer Bewley says it's typical. This is what happens. And so if this court wants to write a broader opinion that says not just of Geraldine, but in general, there's many reasons for Black men to flee beyond consciousness of guilt, I think it would be accurate. But I don't think this court needs to write something when it's all sitting right in the record.
I just want to get back to my question. Maybe it seems like a really minor point, but I mean, we just don't know where DW, what DW's community is. I mean, for all we know, he's visiting from Woodley Park on that day, right? And so I don't know what evidence we have that he has this community knowledge. That I take your point that, the evidence that the police put in could be some community knowledge, but where's the connector between DW and that information? Or is that connector unnecessary? Is that what you're saying?
Sure, it's necessary if we're asking what a reasonable police officer would take from the conduct. And the conduct is an individual there in the community doing things that the officer testifies. I mean, I actually think it's pretty clear from the colloquy that he's testifying that flight is typical. I think it's pretty clear from the testimony, we've got a runner. I mean, that this is not something that they view as unusual.
Does all that mean that officers can never do a Terry frisk of a young Black man under any circumstance where there's some evidence that the community has a history of trying to avoid police interactions?
No, because they're too critical, well, too broadly. I mean, there's
Often
no
those are the
crime here.
communities that need and ask for protection from law enforcement.
Certainly.
At higher rates. So
Certainly, and if the officer had seen someone grabbing their waistband and holding onto it while they were running, which actually the officer testified to here, but the trial judge did not credit, or blading, or a bulge, or any of the things that police officers typically rely on when conducting Terry stops and Terry frisks, or a report of crime. So this is an unusual case in that it's not a report of crime, and none of those additional factors or a hand-to-hand transaction or any of the things that give articulable facts to believe that a crime is occurring. So here, all there is flight, and so it's on the knife's edge of whether or not.
I thought you
there's
said
reasonable
in
articulable
response to Judge Steele's hypothetical that we had more than just flight here.
No, I don't believe we do have more than flight. I think that the government perhaps is going to argue that there's locational context in the record. I don't think that there's sufficient specificity or particularity to, give context, like it's an active open air drug market or the type of thing that was in Wardlow. So I think that when you say, like, is this going to hamper the police, you have to have a recognition that this case is so spare. There was evidence about grabbing and holding the waistband. It was not credited by the trial court. And so it ends on the knife's edge of whether or not there's reasonable articulable suspicion of a crime. They got no report of crime. There was no shot spotter saying there were shots. There was none of the traditional indicia of criminal activity. So in that circumstance, are police going to get the message of just flight when you are a proactive police force engaging in this type of aggressive policing? Can you draw reasonable articulable suspicion from just that? The answer is no, but does that mean that if someone is engaging in a hand-to-hand transaction, grabbing at their waistband, blading, doing any of the things that officers testify to every single day in Superior Court, those are going to be the same cases that they always were?
May I ask you, is your position consistent with what the Supreme Court has repeatedly said to the effect that headlong flight wherever it occurs, is the consummate act of evasion. It is not necessarily indicative of wrongdoing, but it is certainly suggestive of such. You minimize it. You've been minimizing it and saying, well, we don't have other things here. We don't have other kinds of evasive action here. But we have that extremely dramatic evasive action here. And the Supreme Court repeatedly has put a lot of emphasis on that by saying things like what I've just quoted.
That quote
How
comes
do you
from,
deal with that Supreme Court guidance?
that quote comes from Wardlow, which is a case where the state of Illinois and the Solicitor General were both urging the court to issue a holding that flight alone constitutes reasonable articulable suspicion of guilt. In the oral argument, Justice Kennedy was like, are you saying in a swanky neighborhood near a country club, flight alone? And the response was, yes, that's our position. That was the position Illinois was asking the court to take, and that's the position that the Solicitor General was asking the court to take. And the court didn't take that position. They retained a totality analysis, and they talked about the fact that the officers were approaching an open air narcotics trafficking area. And they said, in that context, the flight constituted reasonable articulable suspicion. So that cannot be a holding that flight alone, wherever it occurs, constitutes reasonable articulable suspicion.
It might be, though, an indication that it, in effect, creates a presumption that needs to be, that the defense needs to rebut in order to prevail.
If so, it would be curious that the Supreme Court wrote the entire opinion without saying the word presumption or rebut. They just said that flight can be evidence of consciousness of guilt. It is evidence of evasion. I acknowledge that. And it can be evidence of consciousness of guilt, but then it's the job of the lower courts to decide in context whether it constitutes reasonable articulable suspicion.
Well, I think, and this is why you focused on the question of whether we have unduly aggressive police behavior here, because if we did have that, then that would be a way of rebutting. And it might, now, of course, there's still a problem that just because there are plausible reasons doesn't mean that you win, but we've talked about that before. You focused heavily on the way in which the police treated the other man who ran. They caught him and they searched him. But I don't, it's not clear to me that that behavior is particularly relevant, since precisely because that was somebody who ran and gave the police cause to suspect him. There's no indication that the police were going to behave that way toward anybody who didn't run. And at least none that I'm aware of, no evidence that I'm aware of that the police would have gratuitously searched people who didn't run. And what you focused on, apart from that person who ran, is the way in which two of the people present sort of preemptively, as it were, lifted their shirt or spread their arms. That indicates they've had prior experience with the police, in which the police have been questioning them about possession of weapons or who knows what. But it doesn't indicate to me that there's been unduly aggressive police conduct, a history of which could have explained DW's flight, or completely negated the reasonable suspicion that he was fleeing because for criminal reasons. And that's the difficulty I think I have. To me, the record of the trial or the hearing is extremely sparse when it comes to suggesting any sort of aggressive or unduly aggressive police behavior. We may think it was probable based on what we read in the newspapers or what have you. But if we're limited to the record of evidence, it's hard for me to draw the conclusion How do you respond to that?
I respond to that by saying, I guess, with two things. One is that people have a right to avoid engagement with the police at all. I mean, that is the underlying operating principle in Wardlow. You have a right to go along your way. So the actions of the men who are lifting up their shirt and raising their arms give rise to a very natural inference that they are doing that to be able to go along their way. They don't think,
Could be doing it because they want to cooperate with the police and are concerned about helping law enforcement.
it's possible, but I actually think it blinks reality, given this court's cases with the, repeated acknowledgement that these proactive police forces don't take no for an answer. So that they say, do you have guns? They say no. They don't take no for an answer. Can you lift your shirt? They lift the right side. It's not the left side. They
Well,
lift the
that's true.
shirt.
They could be very annoying. That's true, but does that
And,
get you?
and with all due respect, certain individuals have the right to say, no, thank you. And I don't even like it when the ACLU stops me by the metro and says they want to talk to me. I mean,
I don't like it either.
I have a right to avoid that. And police officers are a lot scarier than those teenagers. I actually change my path. I don't run, but I do change my path to avoid
You
that.
don't jump over any fences or,
I don't, but that's a lot. But and as to the man in the blue shirt, it is true that that man ran. But when Officer Bewley was saying that the action was typical, is it typical for you specifically when you're searching men to have your hand placed in the crotch area? And I'm not going to use the rest of the language that defense counsel used to say that it was typical, moving their hands around, putting up against a fence or whatever. He never says like only for the guys that run. Okay, he says he does that when he deems it necessary to frisk. It's a risk. I mean, in your view, maybe it's a minimal risk because he said it was typical, but he didn't say the context in which he did it. But I do think that the facts on the ground in this case, certainly in context with, I mean, he says that they do the approach that they did because they're trying to make things happen. He doesn't clarify what make things happen means, but he also doesn't limit it. And that seems to me to be something that there would be a very high desire to avoid. If police officers think nervousness or blading or certain reactions or things of the sort constitute grounds for a frisk, then there's a lot at stake, because face down in the concrete with handcuffs and that kind of search, and then up against the fence for up to an hour, that's a lot to want to
Ms.
avoid.
Frankfurt, I'm going to stop you there because I know you've reserved some time for rebuttal and our questions have taken you quite a bit over your time. So we'll reserve your time for rebuttal. Thank you. Mr. Hobel?
Thank you. Good morning, and may it please the court. Mark Hobel for the United States. This court voted sua sponte to rehear this case en banc to address one question: whether the police had reasonable articulable suspicion to stop DW. The answer must be yes. This case.
I didn't mean to interrupt you. Does the podium come up any higher or is it at its height? It's a little hard to hear you. If not, if you just.
I can just sort of craft it. That's.
The
I'll try to
switch is-
speak. I'll
the
try to
switch is
speak
on the
loud.
side.
I'm sorry?
The switch is on the side.
Oh,
underneath.
great. Thank you. Oh.
Thank
That was
you.
my first time.
Yes.
Thanks. This case is Illinois v. Wardlow. The material facts are essentially identical. The police arrived in a location they knew for drug trafficking and gun violence and DW saw them at a distance, took one look, and broke out in headlong flight. Under Wardlow, the Supreme Court precedent that is directly on point, the police clearly had reasonable articulable suspicion for an investigatory stop. Any other outcome in this case would contravene the Supreme Court on this important Fourth Amendment issue.
So I can think of two potential distinctions between this case and Wardlow that it might help if you addressed. One is, my recollection is that in Wardlow, nobody had even gotten out of the car. These were cars, a caravan in motion that upon eye contact with an officer in a car prompted Wardlow to flee. Here you have officers, I believe 3, who exit the car that's there. 2 at least are making their way up the walkway toward DW. It's at least more suggestive that they're coming to deal with that group in a way that there does not appear to be any reason to think that in Wardlow for the individual who's standing there and ran.
Well, in Wardlow, they were converging on that location was the testimony and the evidence. We didn't of course have body worn camera in Wardlow, but the evidence was they were appearing there and that it was the reaction to the arrival of the police that prompted Wardlow to flee. And here much the same is true. Yes, the police had exited their car, but they were still a distance, a pretty far distance away. I think the estimate from the panel opinion was more than 50 feet. As we stated in our original brief, you can see that the group is right by a byway, and Judge Gill, as you pointed out, if DW just didn't want to have anything to do with the police at that time, he could have just walked away through that byway. Instead, he immediately fled.
But just fixating on this point about the distinction between Wardlow and these facts. I mean, yes, in Wardlow, they're converging on a location. I mean, they seem to be going to the place where they expect to see the buyers and sellers. They see Wardlow on the street, not in the place where they see the buyers and sellers, and he's not buying or selling. He's just on the side of the street. He sees them, they see him, he runs, they stay in the car. I think they actually just like watch him run and then circle around and pick him up. So that just seems very different from in this case where it seems pretty obvious, and I think that the officers testify that they're there to get out of the car to engage with the group that DW was part of, right?
I guess I disagree as a factual matter. I think the trial court found that there was no engagement. Nothing had been said by the officer. Nothing.
I didn't say that there was engagement, but it's, they barely let the car stop when they're rolling out of the car to head towards the group of men that DW was a part of, which is different than they're driving past Wardlow, who's standing in a doorway, possibly as a lookout for the drug activity that they're heading to. So it just seems like that's a distinct factual scenario.
The facts are distinct in that way, I will grant you. There isn't any legal distinction to those facts. What the Supreme Court was focused on was unprovoked flight. There was no singling out. There was nothing that involved the police, as Judge Gill pointed out.
Sorry, just to stop you right there. I mean, you don't think that there's any difference between the police are coming for you versus the police are driving by? That's not a legally important fact?
Well, directly coming for you versus driving by,
you,
perhaps,
the group
but
that you're in, right?
But those aren't in terms of the facts that we have here from Wardlow. No, these are not legally significant differences. The fact that the police were converging in their caravan on this location, had not gotten out of their cars yet, versus the fact that they had barely gotten out of their car when from a distance, one of the many people around saw them and immediately took flight without any contact. We do not see that as a material distinction from Wardlow, which again is a Supreme Court precedent. It casts a long shadow. It's not limited to, even if it were limited to the precise facts there, It's still an amazing fit for the facts here, but it's not. That case is about principally the circumstances under which flight gives officers reasonable articulable suspicion, and at least these circumstances, officers have reasonable articulable suspicion.
Is it your view that flight alone, if unprovoked to the degree it was unprovoked here, if you're using that term, without regard to evidence of prior criminal activity in the area, can suffice to support a terrorist stop?
Yes, absolutely. Absolutely.
And are you aware of courts that have held that?
Yes, actually, and we can submit a 28K letter too, but I'm sorry, I'm putting the wrong case here. United States v. Lachey from the Seventh Circuit was a 2006 case. Give me just one moment. Yeah, United States v. Lachey, 461 F. 3rd 857, 2006. The Seventh Circuit held flight from a law enforcement officer gives that officer reasonable suspicion to pursue a suspect and conduct a Terry stop. And then just to note one more point there, while mere presence in a high crime area does not in and of itself justify an investigatory stop, suspicious flight, no matter the area, does. And then they cited to Wardlow's quote about headlong flight being the consummate act of evasion.
So you're citing the Seventh Circuit case, and it cites Wardlow, but is it your position that Wardlow itself establishes that? Or that Wardlow relied in part on the high crime area that?
It certainly relied on the high crime area, but it also, to be clear, did not say that flight alone can never suffice. And in fact, Justice Stevens' dissent specifically stated the court here doesn't adopt a per se rule one way or the other when it comes to flight, when it comes to unprovoked flight. It is, I think, a fair inference from, I think a fair reading of Illinois v. Wardlow is that there are circumstances where flight from police is just so directly incriminating, as the Supreme Court stated in District of Columbia v. Wardlow, flight at the arrival of the police is strong indicia of mens rea. And we would submit that under these circumstances where there is, the police simply show up in a neighborhood, DW takes one look at them and breaks into headlong flight. That is enough. I guess
And
we.
so you're not
You cite the Seventh Circuit case. Your opponent suggests that at least the substantial weight of federal authority is otherwise. Do you agree with that or disagree with that? Or what's your sense of what the rather than one case, what the spread of authority is on that topic?
To be honest, Your Honor, I haven't looked hard enough in terms of what the authority is on if it's just flight. Often there is another factor, as there was here. I would certainly say that the unanimous weight of federal authority that I'm aware of says that unprovoked flight in a high crime area does establish reasonable articulable suspicion under Illinois v. Wardlow.
But I think you would agree with the opposing counsel that things can be systemically provoked, right? You know, let's say this for the record. Every day for the past month, we went down, this is the officers, we went down to the Geraldine apartment complex. We got out of our cars and we searched whoever we could find. We didn't care. We were looking to get the guns off the street. We didn't care what the reasons were. No, we weren't taking no for an answer. And this was day 30. And then you have flight. I think you would agree, no chance that's reasonable articulable suspicion, right?
I don't want to I do not disagree with your premise, which is that there can be systematic contexts, a strong evidence of pervasive police abuse that could I guess negate the inference raised by flight that the Supreme Court has recognized in Wardlow.
And I'm sorry, can I start with an answer to the hypothetical?
Right, now the hypothetical, and that's where I was getting, because I want to be clear, I don't disagree with your premise. I actually disagree with Your Honor about that specific hypothetical. It doesn't matter to the outcome of this case, but here is why. If the police, we know that the police are regularly searching people, are regularly searching people in a specific location to find illegal guns and get illegal guns off the street. It may be the case that more innocent people on balance are going to flee, but it is also certainly going to be the case that more people carrying illegal guns will flee. So the likelihood that the person that the police see running from them.
No, that's a wild answer to me. I mean, they have a right to ignore the cops, right? And the hypothetical is that right is not being respected systemically. We are going to search you one way or the other if we can get you. You're only out if you would like to live as you are constitutionally entitled to live and not deal with those officers is to run away. And you're saying, I didn't even say that they recovered any guns. For all I know, let's say in the hypothetical they haven't. They don't have really good reason to think it's there. One officer got mugged there 10 years ago and they've had it out for him ever since. Quite still is a reasonable articulable suspicion with that degree of systemic policing?
Again, I want to be clear that to the extent that I disagree with you, Your Honor, that does not matter to this case. But as a matter of logic, if everybody knows when the police show up that they are looking for illegal guns, it seems at least as likely that the likelihood that somebody who flees from them is carrying an illegal gun goes up as it goes down.
And that seems like not good math. Not that I'm trying to do it, but as mathematically, but that would work as a justification only if you think there are enough people there who have guns that the effects balance out so that it's reasonable for the police to suspect that among everybody who's going to flee, because I mean, basically anybody who knows of that policy you could think would flee, or at least, would calculate the risks of fleeing or submitting and would have innocent reasons to flee. Everybody has innocent reasons to flee. So if everybody has an innocent reason to flee, and only 5% of people actually have guns, then you shouldn't have articulable suspicion to be seizing any of them. So I'm not sure that that the risks on both sides would be increasing works out to a conclusion that's reasonable to search everybody. I think it might suggest the opposite.
Yeah, I sort of knew going in I was going to take some flack for this answer. I know that this came up in Mayo, and again,
I invited you to agree.
Yeah, I disagree as a matter of logic. Again, it doesn't matter. I think we all can agree under Illinois v. Wardlow, the fact that there are plausible innocent reasons to flee from the police does not negate reasonable articulable.
Does that mean, what do you think of the hypothetical, which is actually not a hypothetical, because I've seen this happen where police pull up, everyone runs, as Ms. Frankfurt said, they scatter, everyone runs. Is there a reasonable suspicion for each of them?
I think that makes it harder. I think we would need to know more because they're not singling themselves out in the same way that Wardlow or DW were.
Does it matter how many everyone there are? I mean, if the police walk up to a group of 500 people standing in line outside something and every single one of them runs, would you say all 500 of them can be stopped? Or is it if everyone is 4, then maybe it's okay? Or is it irrelevant to you how big the everyone is who's running?
My intuition is that the larger the group of people who are running, given what we know about, given sort of common sense about how people interact with the police and the fact that you don't typically see large groups of people just stampeding away from the police. If there is a literal stampede from the police, absent some other information, maybe you're thinking something, it may be more plausible to infer that something else is going on here. But if you have one person or 2 people here who are standing together as part of a smaller group, separate themselves without any interaction from the police, especially in a location where police have a reason to believe they will find, because they found them before, illegal guns and drug trafficking. That is Illinois v. Wardlow, and that is this case.
But do you think it's reasonable to say that the officers here knew that innocent people would be submitting to the officer's authority? They testified that lifting of the shirt was typical. Is it reasonable to say those officers knew and expected that would happen and that innocent people would be doing that?
I'm not sure we can infer that from the record, because that in terms of what the officers believed about people who raised their shirts, who stuck out their arms, It is notable that the police here immediately began pursuing the one who fled in headlong flight, whereas the one who lifted up his shirt, the police actually paid him no attention. They ran right by him. He was with DW's group. It is, as the Supreme Court has recognized, headlong flight is the consummate act of evasion. It makes you stick out, and DW stuck out to these officers. I would note, in terms of innocent reasons, Wardlow specifically addressed, said, respondent and amici also argue that there are innocent reasons for flight from police and that therefore flight is not necessarily indicative of ongoing criminal activity. This fact is undoubtedly true, but does not establish a violation of the Fourth Amendment. Among the amici was the NAACP, which submitted an amicus brief in which they stated, the currently troubled state of police minority community relations is highly relevant to understanding why citizens flee from police, and overwhelming evidence shows that minority citizens fear law enforcement officers because of systemic harassment and abuse. So the Supreme Court in Wardlow specifically considered arguments about innocent reasons for flight having to do with highly policed urban communities, and still held that flight under the circumstances presented in Wardlow and here established reasonable suspicion for a brief investigatory stop. And that's the only issue before this court.
Take you back to how you relate Wardlow to some of our courts precedents, Mayo and Posey in particular. If you say that you view the facts of DW as being almost identical to Wardlow, and I think I would agree that they're more similar to Wardlow than they are to the facts in Mayo. Why, in seeking to stay the decision in DW for a period because of concerns about the court's decision in Mayo, why do you think Mayo precludes a result that you think would have been a viable result under Wardlow? So I understand you to be saying, in DW, we have flight like we did in Wardlow. We have flight, we have locational information about crime in this particular area like we did in Wardlow. Therefore, there was reasonable articulable suspicion. Why do you think Mayo, an analysis under Mayo would change your conclusion there?
To be frank, Your Honor, the bigger question of concern here is Posey.
Okay, but would you start with Mayo and then maybe go to Posey?
Right. I don't mean to.
Or you could start with Posey.
Right,
then come
and the
back
reason
to-
I want to start with, because Posey is really the bigger obstacle and the bigger challenge for the panel. Posey appears to state, I don't mean appears to state, Posey states unprovoked, it says, the government argues that unprovoked flight in a high crime area is enough to establish reasonable suspicion. It's something that we have no doubt that more is required. In other words, Posey really does suggest unprovoked flight in a high crime area, it is not enough for reasonable suspicion. And that is directly contrary
But
to Wardlow.
Posey was a case where the government was saying that there was a reasonable articulable suspicion to believe that Mr. Posey was involved in a robbery. I don't think that the government argued that there was just generalized reasonable suspicion to stop Mr. Posey for a crime. Like, that just wasn't their argument, as I recall. And so, the concluding paragraph, or the penultimate paragraph is, under the totality of these circumstances, the officers approached the group and acted on a hunch short of individualized, particularized knowledge needed to stop Mr. Posey on suspicion of robbery, which was directly responsive to the government's argument. We didn't look beyond the government's argument to see if there were any other arguments to be made in support of reasonable articulable suspicion that perhaps weren't even preserved in the trial court and weren't before us on appeal. So in that context, we then went on and said something about flight, but it was in the context of looking at whether or not there was reasonable articulable suspicion for a robbery. What's wrong with that analysis?
Well, there were other things going on in Posey, but the specific language that I'm pointing to, and I'm quoting here, the government suggests that Mr. Posey's presence in a high crime neighborhood coupled with his flight from uniformed officers is enough to overcome the aforementioned deficiencies in the evidence before us. We harbor no doubt that more is required for officers to develop reasonable articulable suspicion of criminal activity justifying a stop. I mean, that was a clear part of Posey's holding and
Right. Once again, the relevant criminal activity is involvement in a robbery. I mean, I don't know that any other criminal activity was alleged or any other reasonable articulable suspicion was alleged separate and apart from that.
Right. And the principle is effectively the same. The police arrived in a high crime neighborhood. They had even more in Posey in that they had a report of a recent robbery and a somewhat sketchy description.
Isn't that the problem? We didn't know how recent the robbery was. I mean, the complainant was still around, but who knows, like, you know, that the police took 15 minutes to show up or 3 hours or, you know.
That
That
was
just
all
wasn't
part
the
of the
record.
picture. But even if you boil it down to the argument that we made, the government did make, unprovoked flight in a high crime neighborhood does establish reasonable suspicion under Illinois v. Wardlow, and Posey explicitly rejected that. And DW has relied heavily on Posey, especially in the original briefing when we argued that DW's unprovoked flight in a high crime area established reasonable suspicion. DW came right back at us with Posey, and the panel felt bound by Posey, which Mayo endorsed Posey, cited Posey repeatedly with approval. So Mayo is the latest word, and I can certainly get to Mayo and some of the contradictions there, but Posey very explicitly goes the other direction from Illinois v. Wardlow, and we think Posey was wrongly decided and ultimately was a constraining.
It goes the other direction from Wardlow. What do you mean? That it doesn't take into account locational information?
In that Wardlow clearly held that unprovoked flight in a high crime neighborhood, at least under the circumstances presented in Wardlow and presented in this case, is sufficient to establish reasonable suspicion. Posey suggests otherwise, suggests that unprovoked flight in a high crime neighborhood is not enough and more is required to establish reasonable suspicion. That is inconsistent with Illinois v.
I mean, so, you know, I was pressing your opposing counsel on, you know, the hardline view that it's never enough. And I think that's, I don't think she disagreed with me there. I think it's clearly true that it's not always reasonable articulable suspicion, but I hear you suggesting that it is. Let's say these officers came up unprovoked, with no sirens on, they don't give any commands, and somebody sprints 3 feet inside of their front door in their house. The cops are 100 feet away still, they go inside. Do you think they have reasonable articulable suspicion? Let's say they come back out 20 minutes later and an officer is lying in wait because they think they have reasonable articulable suspicion to seize them. Do you think they have it? I went inside when the cops showed up. I didn't want to mess with them. That doesn't sound like you have like plenty of good reasons to go inside if the cops are coming. That you think that's reasonable articulable suspicion? That is flight in a high crime area from police inside your house.
Right, and I find it difficult to characterize a few steps to your front door as flight.
I mean, I think in Posey, the only representation was they were on the unit block of M Street. I believe there was a representation that it was several feet away where the group was standing to the front door of the Tyler house. The officer testified not a far distance. It was not far. So I don't know, however many feet, 10 feet. However many feet is enough for you to agree that that's enough to be flight. And I think Posey, we have no reason to think it was more than several feet. That inside, like running inside, is not particularly suspicious.
Right, and
Do you agree, or do you think that would be they would have reasonable articulable suspicion to stop that person, once they emerge from their house 20 minutes later? Or
I think this is, the character of the flight does matter. It is certainly a factor. The flight evidence here was even stronger than Wardlow because it was prolonged at such a distance at such high speed with the jumping of fences. Conversely, if you have somebody who it just looks like goes inside their door to avoid speaking with police, that seems to come a lot closer to the statement in Wardlow that, of course, everybody has a right to avoid speaking with the police.
I guess I'm just wondering if you're pressing for a categorical rule that, I mean, it sounds at times that you are, flight in a high crime area is reasonable articulable suspicion. Is that a categorical rule that you are asking us to endorse?
I think it is closer to, we'll put it this way. I think in an ideal world, yes, I think it is a clearer rule, and I think other courts have endorsed it. The court does not need to do so here, and given the fact that Mayo was recent in a 6-1 decision of this court, we don't need to bite off more than we can chew. The material facts.
Well, also Mayo, we never described the flight as unprovoked. I do not think you could fairly describe the flight in Mayo as unprovoked. I think Mr. Mayo, it was made quite clear to him that so I suppose I should say, is your categorical rule unprovoked flight in a high crime area is always RAS. And you could carve out Mayo by saying, well, that was provoked, at least in the sense that they made it clear to Mr. Mayo he was not free to disengage.
Look,
I hear you saying, yeah, kind of, but you don't need to go there. Is that the answer?
I think more or less, I think the starting point as always is Illinois v. Wardlow, which addressed these two factors, high crime area and unprovoked flight.
So
There may be-
how much does this now turn on the elusive footnote 1 in Glover v. Kansas, where the court said that the particularized suspicion has to be that the particular citizen was engaged in a particular crime. And so the question is, when you've got flight alone, you're less likely to have an indication of a particular crime involved as opposed to just the flight. Whereas if you have other factors, then it might tie that flight to something like a drug transaction, as in the case of Wardlow, or a gun crime if you see a bulge in a pocket, something like that.
Right. Nothing in this case turns on footnote 1 of Kansas v. Glover. Even if it were the case that a particular reasonable suspicion for a particular crime, the particular crime here is carrying an illegal gun. The officers testified they recovered numerous firearms.
Where is that substantiated? Right, I mean, this record is developed pre-Mayo, so the officers are still using the talisman of high crime, right? And they're pressed on high crime, and they don't really have a good answer of what high crime is. Just kind of what I think high crime is, right? You know, is essentially their testimony. You know, high crime is what I believe. But when they are asked specifically about guns, they have zero information about the Geraldine complex and guns. You're looking at me quizzically.
Oh, I'm sorry, Your Honor.
Am I wrong about that? I saw specific testimony about the 7th district, and that, you know, last year, I can't remember what year the hearing was, but the officer testifies last year there was 100 guns, the year before 200 guns, or maybe it was vice versa. But 7th district is a big place. Includes Bowling Air Force Base. I mean, it's, you know, large territory. So as to Geraldine, the apartment complex, there's no testimony about how many guns they've recovered, not last year, not last month, not last week.
I disagree. I think there was specific testimony from Officer Ewing that they had recovered numerous. He personally.
They say a lot, right? Like, I mean, Ewing says, I've been to Geraldine complex a lot, and every time I go there, well, not every time I go there, I've been there a lot, and a lot of arrests I've made have been felony arrests that pertain to firearms and narcotics. So he says a lot. Doesn't give a time frame and says a lot. But he's also asked, how many firearm arrests have you made in your career? And he has been an officer for 4 years. And he says, it's more than 5, I think. That doesn't, I mean, his idea of what a lot is, if, you know, I mean, he says felony arrests that pertain to firearms and narcotics. So, you know, already the a lot is a combination answer. And then he says, I think I've arrested 5 people over 4 years for guns. So that just doesn't seem like very good evidence about what's coming out of Geraldine Complex. I didn't see any testimony from Officer Bewley about gun crimes. He's asked about what high crime means to him. And initially he says, well, it's 5 to 10 unspecified crimes in a certain amount of time. And he would like to believe, is his language, that Geraldine Complex is a high crime area. So he never says gun crimes. And then there's some follow-on testimony about, well, maybe he's saying 5 to 10 over a year period, but it's never specified to be guns.
Right. And I think that the other piece of testimony was Officer Ewing was asked, what would you label, essentially, how would you characterize a high crime area? It's where we consistently recover guns. And that testimony was cited.
Yeah, but then he's asked, you know, can you give a number? And he says, I don't know that there's a particular number that I could state.
So
I mean, it's all impressionistic. And I would think that at the very least, in order for a judge to be able to evaluate the value of an officer's assessment of an area as high crime, they would need some sort of facts. I mean, not necessarily statistics, but again, like, I was there last week and the week before and the week before that, and I recovered guns every single time I was there.
Right. And obviously that would be very, very strong evidence, but that's not the baseline. I mean, Wardlow considers it a relevant factor. And the specific testimony in Wardlow was something to the effect of, it's one of the high narcotic trafficking area in the 11th Police District in Chicago.
That may be so, but what makes it into the opinion in Wardlow is that the officers are on their way to an active area where they anticipate seeing buyers and sellers, right? Like that they're on their way to an open air drug market, right? Which is not what we have here. They're not anticipating seeing people, you know, showing off their guns and comparing guns. They're just going to see if they can stop some people and pat them down and find guns.
So to be clear, open air drug market is not in the opinion.
I understand that, but it says, you know, buyers and sellers, they're en route, right? They're closing in on that area where they think that people are going to be actively engaged in drug sales.
Right. It was a live issue in Illinois v. Wardlow, whether the area was defined enough to be considered a high crime area. If you look at the respondent's brief, at Wardlow's brief, they argued, Wardlow specifically argued, this is not a defined enough area to be considered high crime to add anything to the analysis.
Right. I take it that we don't have that issue here. We have a defined area. We just don't have any content as far as you specified gun activity in response to Judge Schenker's question. And so I'm just saying there's no evidence of gun activity here other than just kind of, well, my impression is that there's a lot of gun activity here. I don't know how a judge would evaluate that.
My point is simply that there is the Supreme Court, on less powerful evidence than there is here, much vaguer evidence than there is here, considered the location to be a high crime area and factored it into its analysis. This court can't demand specific numbers that were not present in the Supreme Court precedent on the subject.
But
Now,
you don't see a difference, and I'll stop at, after this if we're just butting heads, but it's one thing to say, I'm going to a place where people are actively selling drugs. It's another thing to say, I'm going to a place where I think that there has been criminal activity. What kind, I can't really say. How much, I don't know. It's just my impression that it happens there, right? That's the distinction that I see between this case and Wardlow.
so the question, I think, is whether police can reasonably expect to encounter people who are engaged in this type of criminal activity. It's an objective test. It just isn't, and here, based on their frequent experiences patrolling this particular complex where they had recovered numerous firearms, numerous drugs, responded to many violent crimes, and where there was credited testimony that the police consistently recovered illegal firearms at this complex. That is enough. Specific numbers, and I don't mean to belabor the point, but just the relevant question here is what is an objective officer thinking at the moment of truth, at the moment of when the person starts running, when the decision whether or not to make an investigatory stop needs to be made. And at that point, it is unreasonable to expect an officer is going to have a specific number in their head. They are going to be drawing on
I
experience.
hear you. I guess, is there actually testimony that they consistently recover guns from this neighborhood? I mean, I keep getting back to what's the role for a judge here to evaluate this? Because it seems like if the officers don't have to give any foundation for their impression that something is high crime, then that is insulated from review, and it just becomes, well, potentially there's a bias that this neighborhood has this character, and so that's, X points of reasonable articulable suspicion in the balance. And I'm struggling with the answer, that there's really no way to get at it. It's just, well, if the officer says, I mean, effectively what you're saying is, okay, use high crime or just say, we think there are a lot of guns there. It's the same thing and nobody can question it.
I don't know what the alternative would be other than the approach the trial court took here that is consistent with Wardlow and how it handled this type of evidence. There was testimony to both officers testified it's a high crime area. The prosecutor asked, what do you mean by that? Elicited testimony about their experiences there, including the types of reports they had responded to. One officer also testified there were citizen complaints about selling drugs out in the open there in the complex, multiple firearms. There was very extensive cross-examination by the defense.
That's a very important fact to you that you hammered on so far. They were, the officer was asked, one of the officers that was asked about those complaints and said that specifically there have been multiple complaints, not necessarily that day, about drug activity in front of the building, right where the officer got out and they intended to speak to people about. And so isn't that a strong similarity to Wardlow? I'm wondering why that hasn't been much of a focus so far.
It certainly goes beyond what was present in Wardlow, and perhaps it should have been. I mean, it is a fact, and the officer's testimony about the area was credited that they have received complaints, not necessarily that day, but about open drug selling in the Geraldine complex. So one that substantiates their own testimony about their experiences there recovering guns and drugs. And two, I would submit, that it does tend to indicate that, and this goes to, I think, a point that DW is raising repeatedly, the police presence is not entirely unwelcome at this complex. People are complaining about drug sales and they are bringing in the police to try to investigate and resolve that. So, I think that goes to both the high crime area aspect, but it also goes to, even if it were true, that a record could be created about a pervasive and abusive police presence and pattern of patrolling in a location that could negate the inferences that the Supreme Court said were reasonable in Wardlow. That record hasn't been created here. I think
Can I ask
Judge,
whether
Does Wardlow
you-
require that? Sorry, do you?
Let's ask the same questions.
You said a number of times that Wardlow is the floor, essentially, in terms of what, did you say that? I thought
I don't believe I put it in those terms, but I'm sorry. Yeah.
It's been said today that Wardlow is sort of the floor in terms of how you look at establishing reasonable articulable suspicion with flight and other factors. Do you read Wardlow to preclude a requirement that, for example, we say in Mayo, the inquiry should turn on quality and specificity of the information with particular focus on the recency, frequency, and geographic proximity of the relevant criminal activity? Any general evidence about the crime in a location must be relevant to the conduct at issue. And I hear you saying, on the one hand, we have that in DW with the testimony that was here, but then I think I also hear you saying either it's not appropriate to require that or you don't need to require that kind of specificity. Am I understanding your argument correctly?
We have that level of specificity here. And it would be very helpful, because DW was the first case, I believe, to apply that Mayo standard to high crime area evidence. It would be very helpful for the en banc court to clarify that if that is the standard going forward, that in its application, it fits to evidence like the type here. Because here you did have a specific part. I don't want to go back over what I've already said, but that would be helpful. In other words, we're not saying the court needs to walk back all of what it said in Mayo about high crime area evidence. It is entirely within the power of the court to say the evidence here fits that. And I think that would be a way to harmonize Mayo's statements with Wardlow on that.
Can I ask you a question? As it turns out, I was going to ask a different question, which is, you said that it might be possible to have a record that would show such pervasive police enforcement as to change the degree of suspicion attributable to flight. I'm paraphrasing you, but that no such record was created here. And I'm curious whether you think that's something that can be established solely through evidence introduced at an evidentiary hearing, or whether instead that's information that exists independent of that. And I have in mind our decision in Carter, which was not a reasonable articulable suspicion case. It was about whether something was a seizure or not, but not based on evidence in front of an evidentiary hearing, but instead sort of taking account of information from judicial decisions and other sources. The court reached some pretty strong conclusions about reasonable fears by Black males in particular, but also more generally people of color, about unwarranted police violence or unlawful police stops and the like, including your opponent cited one of the pieces of information that was in our decision in Carter, that not quite half of African-American adults report having feared for their lives at the hands of the police. In light of Carter, I'm wondering why you were suggesting that the only way to establish that information for purposes of assessing the degree of suspicion to attribute to flight would be through evidence introduced at a hearing, or whether you would agree in light of Carter that that's also information that one could take from now is sort of a holding of the court or in Carter itself.
So these types of inferences should be based on the evidence developed at the hearing. And to their great credit, DW's counsel fought valiantly to put on that evidence. The fact that they weren't successful here doesn't mean they weren't going about this the right way. Just as there are evidentiary requirements on the government to establish the bases for reasonable suspicion, if the defense wants to make a record on this type of, and you know, in part, I've been paraphrasing the final footnote of Judge Glickman's partial, his separate opinion on this point, that hypothetically there could be such a scenario. The record there wasn't that record here.
Well, do you
It
think
is-
Carter's incorrectly decided then? And I mean, then you think is the Supreme Court wrong without an evidentiary record in front of it to say, I mean, in Hodari sort of dicta about the wicked flee when none pursue, or what was said? I mean, was there evidence to support the conclusion quoted by Judge Glickman earlier about flight is, you know, indicative of, you know, it's the consummate act of evasion and strong evidence of mens rea? I mean, there wasn't evidence of all that. That's just judicial. I mean, it's not entirely clear to understand what it is. It's judicial common sense. It's treated as an issue of law, but it's not like there was evidence to support those inferences in the cases like Wardlow. There aren't statistics that say of people who flee, you know, 13% of the people who flee unprovoked at the mere presence of police officers, 27% of them are actually guilty of a crime. Others have other reasons, and that's why we find there's reasonable articulable suspicion. So where is it you think the line is between what it is courts can do without evidentiary hearings and what it is that there's a requirement of case-specific evidentiary showing?
Well, we believe that Carter was wrongly decided. I'm not, but we are evaluating our options. I'm not otherwise prepared to address the specific facts of Carter, but ultimately, as courts of law, courts need to base their decisions on the facts and the evidence. The standard here, reasonable suspicion, it doesn't, by design, is not meant to lead to certainty. There may be
Well, I mean,
plausible and so.
Can I just
Yeah.
pause you right there? Set aside Carter, what about Wardlow? And Wardlow says the determination of reasonable suspicion must be based on common sense and judgments and inferences about human behavior. And, you know, we're people out in the world. We have common sense inferences about how people behave when, you know, they're accosted by police, and if they as a group are more likely to be accosted by police because of, you know, their skin color or their gender or what have you. You know, it seems like Wardlow says we can make a common sense judgment about that. Is that wrong?
The design of these Supreme Court cases on reasonable suspicion is that officers and trial judges are allowed to draw common sense inferences, and these appellate courts are to give those inferences due weight. That's Ornelas. The appellate courts are not in the business of fact finding and should not be drawing factual inferences, contested factual inferences themselves. And I would note that you know, and again, circling back to Wardlow, I do see I've run out of time.
Before you sit
Yeah.
down, I'd like to get a word in if I could, so don't be too quick to rush back to your seat.
Well, I don't think I'm going to run anywhere today, but why don't you go ahead, Judge Glickman?
It would be provoked, though.
Well, I was going to ask you for clarification on something that puzzled me that I thought I heard. I thought I heard that, I thought I heard you saying that for the stop to be justified, the police have to have a specific crime in mind. They have to believe that the flight is due to some specific criminal offense that they are investigating. I'm a little puzzled by that because it seems to me, if you were to take, for example, Judge Deal's hypothetical of the lunatic jumping around in the baseball stadium, there could be many reasons, many crimes that could cause a person to run. The person might be a fugitive from justice. The person might fear that he had just committed a crime the police don't even know about, but if they talk to him, they'll find evidence of it. I don't know why the police have to specifically believe this person is fleeing because he must possess a gun underneath his, clothing, as opposed to this person is fleeing because, or his flight signifies consciousness of guilt of some crime. Help me out there.
No, and I do appreciate the opportunity to clarify that point, Your Honor. The standard from Ward law is reasonable suspicion to believe that criminal activity is afoot. That is the standard. We don't believe that the language in the footnote of Kansas v. Glover was meant to alter that longstanding precedent. The point I was making to Judge Shanker is that even if that were the standard, and we don't believe it is, it would be met here because there was reasonable suspicion of the particular crime based on illegal gun possession, based on the nature of the location where they recovered many guns and DW's headlong flight from police. And I'd note too to that point that the police, when we talk about the police patting down the groin area, there was a reason in the record for that. The officers testified that's where people commonly hide illegal guns. And Officer Buell even testified that he once found a revolver the size, less smaller than the palm of his hand in somebody's underpants. So, that's why the officers are doing that. That's part of the experience and training they bring to bear on this.
So one more clarifying question for you, because your answers led me to believe you may look at it a couple different ways, but on this idea of provoked or unprovoked, is it correct to say that you don't understand this as a binary switch that gets flipped, but instead would rely more on your Lawshay Seventh Circuit type case and say it's about how suspicious is the flight, not really, oh, it was unprovoked versus provoked?
Right. I think the latter type of approach is a way of getting at whether or not it was provoked or unprovoked in the context. It's the inferences, that reasonable inferences that can be drawn, not the only inferences, but reasonable possible inferences that can be drawn from the flight. And the difference between somebody being momentarily startled versus seeing the police at a distance and immediately bolting without any interaction, that latter is what Wardlow was referring to as unprovoked flight, which is the consummate evidence of guilt and an evasion, and is certainly present on the record here, and there really has not been any dispute about that.
But it's not a bright line. It's the totality of the circumstances and all the inferences that could be reasonably drawn.
Right, and Terry is in general is a totality of the circumstances test. But again, given how few Supreme Court precedents there are on Terry stops and the content of reasonable suspicion, Illinois v. Wardlow is one of the major cases. It examines the specific issues, factors at issue here, and comes to a particular conclusion about the existence of reasonable suspicion. And so I want to be clear that you saying something is totality of the circumstances does not mean that when there are minor factual distinctions between this case and Wardlow, that calls for an all new balancing. To a very, very large, in fact, almost total extent, the Supreme Court decided this case in Illinois v. Wardlow, and this court clearly
Sorry, to
found
be
that.
clear, I wasn't focused on the entirety of the case, but on this idea of the flight itself and how we look at it.
Right.
Like you don't think there's a bright line like it either is or isn't, but in determining if it's unprovoked, there's a whole totality of the circumstances we need to be looking.
I agree. I agree with that point. Of course, here the flight is in the heartland of what Illinois v. Wardlow was talking about as the consummate evidence of guilt.
Before you sit down, unless there are other questions, I did want to bring you back to my earlier question about our precedents, specifically in Mayo and Posey. And I understood you to say that you don't agree with how Posey was decided. And is it fair to say you would, in an ideal world, prefer that the court would clarify it, revoke it, rescind it? But Mayo, on the other hand, think could be harmonized with the facts here in some way.
That is a fair characterization of the arguments. In other words, we see Posey as the biggest contradiction in this court's case law with where the Supreme Court has indicated the cases like this should come out. Mayo, we petitioned for en banc review in Mayo. We had that argument. That's to a certain extent we can, our differences with Mayo are, I think, a little bit less than our differences with Posey. Posey really is the case that says unprovoked flight in a high crime area is not enough, and that is just flat inconsistent with Illinois v. Wardlow. And again, the panel which was constrained by Posey strongly relied on Posey to come out a different way from the Supreme Court on really the same set of facts. Yeah.
Right. Thank you.
Thank you.
Frankfurt. I think you reserved 5 minutes for rebuttal.
I want to start by making 3 points on the high crime area or the locational context point. So first of all, as to the factual finding that the trial court made here, it is, each time the officers were cross-examined, the prosecutor ended her redirect by saying, did this have a reputation for being a high crime area? And each officer adopted that. And then really what the trial judge did here was credit the label of the high crime area and the reputation that the officers attested to. As I said earlier, both officers testified they considered this to be a high crime area. 2 officers testified to the fact based on their experiences, which included shootings and a stabbing, and testified to the general reputation of the complex within the Metropolitan Police Department. And then after he talked about the PDS investigator testimony and how the stabbing had occurred 3 years earlier or something, ultimately this testimony does not cause the court to discredit the consistent testimonies of the 2 officers on this point. So the point in Mayo was that as a matter of bedrock Fourth Amendment principles, facts need to be brought to the court for the court to make an independent assessment of whether or not the location was such that there was, geographic proximity, temporal proximity, relevant crimes, so that, like in Wardlow, the officers might think as they were arriving, there would be active criminal activity to put the flight in context. That didn't happen here. It was a pre-Mayo case. To the extent that the trial court was making a finding, he was saying they gave the label high crime area, they said it had a reputation for high crime area, and I credit it. And that is just not consistent with what the court said in Mayo, which was totally bedrock Fourth Amendment principle that the independent facts have to be brought to the fact finder.
Counsel, what
so the
about
fact
the
finder can make an
complaints that your
assessment.
opposing counsel talked about that were made, that the complaints that were made, not necessarily that day, but possibly that the officers were allegedly responding to, that said there was drug activity specifically in front of the Geraldine?
So that was, I believe, Officer Ewing's testimony. And Officer Ewing explicitly said when he came to the area, the prosecutor said, "What were you looking for?" And he said, "We were just in routine patrol. We weren't looking for anything in particular." And Officer Bewley made similar comments in his testimony. At one point in time, he said, I was in front of the apartment complex with Officer Roman. I was in contact with another citizen, not the defendant. I was speaking to them in front of the hallway, just in reference to some complaints that we had received. And at that was the point when Officer Roman told me they were chasing someone in the rear of the location. There was no specificity. There was no indication that they were responding to the area because of those complaints. There was no factual finding from the trial court that what the complaints were, that there was proximity or anything. So it was a sort of what I was doing when I learned about the runner. But both officers testified that they were coming in for routine patrol. They
For all we
weren't looking
know,
for anything.
given that testimony, the complaints could be, you guys keep coming around here, why don't you leave us alone, right?
could-
I
I
mean,
mean, it
we have
could-
no idea what those
We have
complaints
no
are.
idea. So, and it really wasn't the basis for anything. Then as to Wardlow, the government tries to make Wardlow into a
If I
case
could
where,
For you just
the-
a second, they do say specifically that the complaints are about drug activity there in front of the building where they got out at. I'm not saying that that's decisive on its own, but just to be clear, on page 143 of the transcript, that's at line 17 to 20 or so. And sorry, that's more of a statement for me than a question. So, I mean, you can go back to the case law. I just wanted to make sure that that was clear as well. And I don't think that that's necessarily decisive, to be clear. That's just one other piece.
Right, but the
along with all the
complaint
other
could still be, you're not dealing with the drug activity outside of the building. I mean, it just, like, it could be complaints about the police. It's not complaints about the drug activity.
No, I think in the
mean,
transcript, it says the complaints actually are that people are hanging in the building and there's drug activity in front of the building where you saw me get out at. So I stated that I was addressing the complaints and I was speaking to a citizen. So there is at least some that is not about complaints about the police. Complaints that people are hanging in the building and there's drug activity in front of the building.
And it's just generalized and they're very clear in the follow-up questioning that that doesn't apply to any of the particular suspects. So
I think that's right. I mean, I think that the officers were clear before that, that they came not looking for any particular criminal activity or report of crime. And they were clear after that, that they had no link between this person and that
And
activity.
why is that relevant? That subjectively their purpose was to address a complaint or not? I wouldn't have thought that'd be relevant to the Fourth Amendment analysis, what their motives were as opposed to what their bases objectively were.
I think if there was a report of crime, this case would be different. I mean, if there's a, if
Well, I
the,
get that, but it seems to me if I'm an officer and I'm told, here's a report of crime, and I think I'm not going to investigate that, I don't really care about it, and I'm over at this place and I'm looking at things, doesn't really, that's knowledge I have and it's properly taken into account whether that's my motive for whatever action I take thereafter. So I'm just not sure I see the relevance of what their motives were rather than what information they had.
I'm not suggesting motives are relevant. But I am suggesting that if the government's going to put evidence on as to what were the facts that were the reasonable articulable suspicion that they thought they could tie to this particular person. So if it was a case where they said, you know, we knew there was an ongoing burglary and that's the reason why, and they give those facts to the trial court and the trial court credits it, that becomes one of the pieces of articulable suspicion. I don't think in this case it was, and no one was saying they were coming to investigate narcotics activity, that that they gave the source of the information.
Again, I keep running up against, imagine that two scenarios. One, an officer gets reports of criminal activity, but is not responsible for responding to them, but is aware of them, and is at in a particular location for a reason, and then sees some things and adds up all the knowledge the officer has and responds. Different scenario, officer is aware of it and is going with the purpose of looking into them. I would have thought the Fourth Amendment analysis is exactly the same. Doesn't matter what the officer's self-understood task was or why the officer was responding. You just figure out what the officer knew about those complaints. So I keep getting hung up on what seems like the suggestion that it's relevant, whether subjectively they were thinking, oh, part of what I want to do is respond to drug complaints. I just haven't been able to quite get my head around why that's relevant.
Thought there was a suggestion that there was evidence in the record from which a trial court could conclude that there had been recent criminal activity at a particular spot, and therefore that would be context, like in Wardlow, for an individual's context.
So maybe I get where you're going, because I certainly understand the idea that there's a lot of gaps in this information about recency and the rest. So I understand all of that. And I guess I can sort of see a glimmer of relevance if the idea is, if the officer had said I was going to respond to complaints there might be an inference of recency that wouldn't be available if it's just this general language. So is that what you're trying to get at? Because I can sort of get that at least.
I think so.
Okay.
And then I would like to get to my position, which probably isn't surprising to you, that I do not think that Wardlow was assessing the quality of the high crime area evidence in that case. It was baked into the question presented, which was whether unprovoked flight in a high crime area constitutes reasonable articulable suspicion. The intermediate appellate court had looked at the record and said that it found it insufficient and too vague. And the Supreme Court of Illinois had said that in one sentence, that the undisputed and uncontested testimony of the officer was enough to conclude it was a high crime area. That was what the Supreme Court of Illinois said, which, if you were applying that test, it would apply to cases where it was undisputed and uncontested. But then when it comes to the Supreme Court, it's baked into the question presented. And it's interesting, again, in the oral argument in this case, that there's a point in time where Justice Stevens asks to the respondents' counsel, may I ask you a question about the facts? And he starts to ask questions about whether 2 points that are baked into the question presented really are accurate. One, was this really unprovoked? And 2, was this really a high crime area? And he says, have you conceded these facts? And as the respondents' counsel starts to say, no, I have not, both Justice Scalia and Justice Rehnquist jump in. I say jump because they speak simultaneously. And Justice Scalia says, if you haven't conceded it, you should have objected to the question presented. And Justice Rehnquist says, you didn't say that. And they're focusing now on the unprovoked flight because that is what the respondents' counsel had started to talk about. And Rehnquist says the question presented is whether a person's sudden and unprovoked flight from a clearly identified police officer, and you didn't question that question in your brief in opposition. And Scalia says, gee, I didn't really think we were going to get into the facts of this case as to whether indeed it was unprovoked flight. I thought that was a given. And he then says, you should have raised that point earlier. As far as I'm concerned, what we have before us is that question. And because they're folks.
I understand a line of thinking, but I get trapped in the following problem. If unprovoked flight is a somewhat unclear concept and really probably not binary, but instead a spectrum of degree of provocation. And if high crime area also not a very good label, imprecise, then it's not even a coherent legal question to say baked in is, we have no idea how much of any of these there were, but we have a label, which is high crime area. We're not going to look behind it. That's baked into the question. We're just taking it as, I don't know what, a phrase that has undetermined content. And we're going to add it to unprovoked flight. It's baked into the question as unprovoked. So we're going to call it unprovoked, and we're going to determine whether that's enough for reasonable articulable suspicion. I don't understand how that's a coherent question unless you are assessing in the context of the facts of the case. Here is what the high crime evidence was, so we know what that label means in the context of the case. It seems like it's a meaningless question, a meaningless legal question, unless you are taking it in the context of the circumstances of the case. So that's where I get hung up.
Well, I think what they do is they characterize it. So let's focusing on the locational context or the high crime area. They characterize it. They were converging on an area where they had reason to believe there would be narcotics activity, and there would be buyers and sellers and lookouts. So that is the factual context that they are putting into the mix. But there's nowhere in the opinion does it say this is how we suggest a court review evidence to assess whether or not it rises to a level. I mean, nowhere does it say this is consistent with all Fourth Amendment jurisprudence, which is that the facts have to go to the trial judge, and then the trial judge has to make an assessment to make an independent determination.
Does that
You have a
put
new magistrate.
Mayo in conflict with Wardlow in your view? Mayo says much more specifically what kinds of facts must be put into evidence to establish context of the location. That you don't see that as a conflict with Wardlow at
I
all?
don't see it as a conflict at all, Your Honor, because I don't think that was the question that the Wardlow court was asked to decide. There could be a case that goes to the Supreme Court that asks it to decide.
But this is the issue of, I think you may have said this earlier, of Wardlow being the floor, not necessarily precluding jurisdictions from requiring more robust evidence around these.
I think there have been a number, I mean, I had them at my fingertips when I argued Wardlow, but there have been a number of courts who have talked about the type of evidence that is necessary in order to give a court an ability to make an independent determination. And none of them thought that they were bound by Wardlow, because none of them thought that Wardlow spoke to that issue. And really, the analytic conception here is that it's a proxy for a report of crime. If you have a report of a burglary in progress and police officers arrive on the scene and someone starts to run, that flight is viewed in context. In Wardlow, they were taking as given that they were approaching an area of expected criminal activity, then, there, and a particular type. If it becomes a categorical rule that there are these two boxes, and if you check them, then it's reasonable articulable suspicion, then that diverts from what the Supreme Court was saying we should be doing a Wardlow.
What
And
if you
we
have a
Kansas versus Glover problem.
What if you have a situation where a police officer is just walking a beat, patrolling a random area, and someone flees? You don't have in that context necessarily a report of criminal activity. He's there in a preventative mode, perhaps arguably like the crime suppression team was in the Geraldine apartments. You're not suggesting that he or she couldn't determine there was probable cause from someone coming across their path fleeing just because there had not been a crime that the officer was investigating at that moment, are you?
I don't think that this court has seen that case yet, which is light with absolutely nothing else to put it in context. I think that we're arguing here that the background of aggressive policing and the response of the individuals on the scene put DW's flight in context, and your case has stripped that out, but it's also stripped out any locational context, which is what in Wardlow made it rise to reasonable articulable suspicion. So that would be a case where very few courts have said that absent any context relating to the location, if it's just flight, that would constitute reasonable articulable suspicion. The court has no further questions.
If you stay long enough, we could think of some.
I wrote my list, but I think you guys are on it, as we say. I would ask the court to reverse.
All right. Well, we thank Ms. Frankfurt and Mr. Hobel for your arguments today, and thank the government and the Public Defender Service for your briefs in this case. And we stand adjourned at this time.
All rise.